Many of you may know, recently, the Department of Justice launched its Corporate Whistleblower Awards pilot program. And under the pilot program, eligible whistleblowers are able to receive up to 30% of any forfeiture award issued in a given case. However, in order to participate, the whistleblower must be eligible. And there are 10 requirements that each whistleblower must satisfy. First, the whistleblower must be an individual. Unfortunately, corporations cannot apply under this program. Second, the whistleblower cannot be eligible under any other federal program. Third, the whistleblower cannot be a law enforcement officer or official at the time they were acquired the original information that they hope to give to DOJ, nor can they be a foreign official at the time they acquired the original information that they hope to give to DOJ. Fourth, the whistleblower cannot be a meaningful participant. What that means is they can't be involved in the directing, planning, initiating, or knowingly profiting from any misconduct. Fifth, the information provided by a whistleblower must be original. It has to be in writing, and it has to be the individual's own independent knowledge or analysis, and it can't be public information or information that the DOJ was already familiar with. Sixth, the information provided must pertain to one of four subject areas: financial institutions, foreign corruption, domestic corruption, or healthcare fraud. The seventh factor considered by the Department of Justice will be whether the information was voluntary. That is, it was provided before any DOJ inquiry or demand. Eighth, the information must be truthful and complete. That is, that the whistleblower provided all information which they had knowledge of, and they did not lie or conceal or mischaracterize anyone's role in the misconduct. The ninth factor is cooperation. That is, the whistleblower must produce all documents, records, and other evidence, and if requested, they have to work in a proactive manner under the supervision of law enforcement officers. The final requirement is the forfeiture threshold. It has to be over $1 million. What that means is the forfeiture in any given case must exceed $1 million for the DOJ to consider a whistleblower's role or active involvement in the pilot program. The DOJ is aggressively incentivizing individuals to provide information. As a result, there's an increased risk that whistleblowers were reporting suspected misconduct to the Department of Justice, as individuals seek to take advantage of any cash incentives that they might be able to obtain through this pilot program. Accordingly, companies may wish to review internal investigation procedures regarding whistleblower complaints, and they may wish to develop or modify a framework for determining when they should report to the Department of Justice. They also want to consider who would be involved in those decisions and at what stage to engage external counsel. So Dickinson Wright will continue to monitor the developments in this pilot program and the other programs issued by the Department of Justice. If you have questions or concerns about whistleblowers, please feel free to contact me or anyone in the internal investigations practice at Dickinson Wright. Thank you for your time today.